for women. I'm not sure if everyone has heard that Roe v. Wade has officially been overturned. It's obviously not what our panel is about, but I'm sure it's on everyone's minds. And I think maybe at some point we could do a panel on that or CPD on that, just in terms of even support issues, because it's a pretty dark day, even though we don't live in the US. Anyway, moving on from that, we do have a great panel today. It's the managing criminal file at the trial stage, which is a huge topic, talking about trial issues, running a trial. We have lots to talk about. The estimable Sid Freeman is here, and she has lots to say. There's lots of other things that we could cover in other CPDs, but we've got some general things to talk about in terms of themes and ideas, and then some practical tips as well that we hope everyone will enjoy. And for those of you who don't know Sid, she's been practicing criminal law since 1994, has a fascinating biography, including having worked as duty counsel, working as an intern for a couple of years in the psychology department at a federal penitentiary. Sid, I need to hear about that at some point.
Working originated.
That's fascinating. Working as a sole practitioner, having appeared in the provincial court, superior court, court of appeal, and conducted hundreds, probably thousands of trials, has tons and tons of experience running trials, cross-examining people and so on. So no better person here today to talk about managing a criminal file. So we have some things to talk about, and then we'll leave 10, 15 minutes at the end for some questions, and we hope you enjoy it. So having said all that, Sid, I'm going to turn it over to you at this point to get us going.
Thank you, Jen. I'm glad you brought up the horrifying news out of the US today. And I did, as our president, want to just address the members who are here about that. It's a hard day for us. And as Jen has indicated, the right for women to control, for us, or at least for our American sisters, the right to control our bodies, the consequent right and ability to control the course of our lives was obliterated today by the Supreme Court in the US. And in that judgment, they hint that the court is eager to abolish even more hard-won rights, not just for women, but in other areas as well. And it's hard to feel like there's not a war on women with this decision. It's hard to feel that we've been pushed backwards. And we must allow ourselves time to grieve, because there's a lot to grieve here. But when we're done grieving, we have to pick ourselves up, we have to dust ourselves off, and we have to march straight back into the battle. Because when you're in hell, you don't sit down, you keep going. And we will keep going. We will march forward together, arm in arm, and we will fight until we make sure that our rights in Canada are secure, that our places in the courtroom, that our places at the partners' tables, our places on the bench, and our places at the top of our chosen profession are secure. We will never surrender. Now, with that having been said, let's talk about how to run a trial. There is some confusion among some, and rightfully so, about just what exactly is our role. Are we defending the individual? Are we defending something else? What exactly is it we're doing when we're standing up in a courtroom? A lot of people have a lot of different ideas. I'm going to tell you about my idea. Could I be made a co-host so I could share, please?
Just a moment, Sid, I will do so.
Okay, so let's go back to what I was saying. Some people misunderstand the nature of courage. Courage is not having no fear. Courage is being terrified, but going ahead anyway. And Jen, I'm sure you've heard this before. A good friend of mine, Jen's partner, Dirk, has a view about the two states of a criminal defense practitioner. I see you smiling, so I know you know what I'm going to say. Dirk says, as a criminal defense
I can't believe I'm hearing him speak in this conference.
his view of the two states are that a criminal defense practitioner oscillates between terror and boredom. And there's a lot of truth to that. Part of being fearless is casting aside any ideas of imposter syndrome. So we see examples of this in other places. I'm going to show you one, if I can. If it will let me, here we go. Okay, here's an example. This is a picture of an eagle catching a fish.
We cannot see yet.
Oh,
Cannot
okay.
see it, Sid.
Hang on.
Are you still you're still the host?
Yes, she.
Can you see it now?
No.
Not yet.
Second. How about there?
Yes.
Okay. This is an eagle catching a fish. Just out doing his thing. The eagle is not thinking, I hope this fish thinks I'm professional looking while I'm catching him. And the fish isn't thinking, I hope this fish thinks I have good eagle technique. We see the same in other examples. I'll show you another one. Here's another example. You see the bear?
Yes.
The bear is not thinking, boy, I hope that seagull standing there thinks I'm a good fisherman. And the bear is not thinking, I hope I don't look too goofy while I'm trying to catch this fish. The bear is just being the bear, just being who he or she is. That's what I would encourage you to do. Forget about yourself. Focus on the work. Take the focus off of what the judge thinks of you. Take your focus off of what the Crown might be thinking about you. Take your focus off of what the client might think about you. Focus on the job at hand. Focus on being the best that you can be. And in order to do that, in order to focus on being the best that you can be, do you. Don't try to imitate a courtroom style that you've been told is the right one or the best one or even a good one. Don't try to force yourself into a mold that is not you. Don't be a bear if you're an eagle. Don't be an eagle if you're a jaguar. Yes, you have to be professional, but you can do that as you. Figure out who you are. Develop a style that suits you, that is authentic for you, that you're comfortable in. And I say this, but remember, you will always need to keep a little chameleon in your DNA because different witnesses sometimes require different handling. So for example, you wouldn't necessarily cross-examine a child sexual assault complainant in the same way that you would cross-examine a police officer that you believe is committing perjury. So you have to have a little flexibility in your style while still being you. Let's move on to some nuts and bolts about an overall approach to the trial. The way I approach trials is like a puzzle, and I treat every piece of evidence like a puzzle piece. I've never had a case where there are sufficient puzzle pieces to complete the picture. The Crown will say in a case that the scattered pieces that you have suggest the picture is one thing. I treat my job as challenging the individual pieces to take them off the board, challenging the idea that the pieces create, which the Crown says, challenging where appropriate what the picture is when you put the pieces of the puzzle together that are remaining on the board. And sometimes where it's appropriate, you paint an entirely different picture using those same puzzle pieces, right? And then at the end of the day, you go to the jury or the judge and you say, look, as long as there is a reasonable alternate explanation, you can't rule out reasonable doubt. You don't have to decide between the two different scenarios. That's not the point. You don't have to choose between the picture the defense paints and the picture the Crown paints. But as long as there are alternate pictures out there, you haven't pushed the Crown beyond reasonable doubt, or the Crown hasn't pushed themselves beyond reasonable doubt. So how do we do this? Obviously, the first step is to review the disclosure. When I review the disclosure, I'm looking for what evidence is going to be in presenting the case and what evidence is going to hurt the defense. Determine how to neutralize as much of the harmful evidence as possible. Ask yourself, can it be excluded through a charter application? Can it be excluded on a probative value prejudicial effect analysis? Can it be excluded by a rule of evidence? Can its negative impact be diminished or eliminated through other evidence or through a common sense explanation or inference? And when you turn your mind to looking for evidence that helps the defense position, you start by looking at the Crown's own witnesses. There will be no greater satisfaction in your career than turning the Crown's witnesses against the Crown's case. If you can do that, you are well on your way to an acquittal. The Crown's case is not just about the Crown and the Crown's theory. Use their case to adduce as much of your case as possible, and use your cross-examinations to adduce helpful evidence and to diminish hurtful evidence. Don't forget, the judge or the jury are forming opinions about the case from the moment the first piece of evidence is called, whether that's an agreed statement of fact or whether it's a witness. Do not wait until the Crown has closed its case and the opinions have hardened before you start scoring points and casting doubt. Always try to use the Crown's evidence against them wherever you can. With respect to cross-examination, it's actually pretty simple. In the end, ultimately, cross-examination is just a series of statements with question marks tacked on the end. Cross-examination is your most powerful weapon in a trial, so don't throw it away by using the W5 questions. Don't resort to W5 in a cross-examination. Now, there are some exceptions to that. If we have enough time in the end, we can come back to that. Jennifer and I spoke about a future CPD where we do a session completely on cross-examination, because I think that would be helpful to the members. But if we have enough time, like I said, we'll come back to it in this session about it was some examples of where you would ask a W5 question. Now, you may be sitting there asking yourselves, what is a W5 question? The W5 are who, what, where, why, and how. Now, how obviously doesn't start with the W, but it is a W5 type question. I'm going to give you some examples of how to ask a cross-examination question. Instead of saying, what color was the car, knowing from the disclosure that the witness had said the car was red, you would say to the witness, the car was red. Statement with a question mark on the end. Instead of asking the witness, did you see the suspect's face, knowing from the disclosure that the witness has said no, you would instead tell the witness, you did not see the suspect's face. Statement with a question mark on the end of it. To be effective, you have to build some credibility into the witness's final answer. So the judge or the jury, depending on what you have, when they hear that the witness didn't see the face, or when they hear that the witness say that the car was red, they're like, okay, the witness said that, and you know what, I believe it because of the circumstances around the witness's answer. So for example, compare asking the single cross-examination question, you couldn't see what any of the vehicle occupants looked like, and the witness says no. Compare that to this. You were out for a walk when you saw the drive-by shooting. You were with your friend Hillary. The two of you were standing at the intersection when the shooting occurred. Your crossing light was red. You and Hillary were chatting as you waited for the light. You were focused on your chat with Hillary and watching the lights to see when they were going to change. While you were chatting and watching the lights, you heard some bangs. After you heard the bangs, you turned to locate the source. After you turned, you saw a car speed by. The car was moving very fast. You saw the car for less than a second. You were confused about what was happening. With the speed and the confusion, it was not possible to get a good look into the car. You cannot say what any of the occupants looked like. Now, that series of statements lets the trier of fact understand the context in which the observations were made and the conclusions were drawn, and gives some solidity and strength to the witness's final conclusion. So what you try to do is funnel down to the point that you want to make by going through the circumstances that secure the point as being truthful and accurate and real. With respect to the client testifying, this is always a big issue in a criminal trial, whether or not the client should testify. It's important to remember that the choice about testifying always, always, always is the client's choice to make. I can tell you that within my practice, I'm a big believer in including the clients in the decisions that affect them. So when I get a file, I go through the disclosure, then I go and see the client and I tell the client what's in disclosure. If there are important bits of the disclosure that the client either wants to see or needs to see to understand the situation they're in, I take those bits with me and review them so the client can see them. Sometimes it involves statements or sometimes it involves CCTV video, whatever it is. Then I will run through every option the client has on how to proceed. I'll review the pros and cons of each option, and then I'll make a recommendation and I'll explain why I've made the recommendation that I have made. If there's an option that I would completely rule out, I will tell the client that, and I will explain why that is. But at the end of the day, the consequence of the decisions that are made through a trial are suffered by or experienced by the client. And sometimes they're going to have a long time to sit and think about the choices that were made. And therefore, it's the client's life that gets impacted, in my view. At the end of the day, no matter what happens, I'm going home. But at the end of the day, the client may not. So they need to be comfortable with the important decisions that are made in their case. Now, you know, not every itty bitty decision, whether or not, I don't know, something is an agreed statement of fact or not, as an example, you would explain why you are doing that and why it's the best option. But this decision to testify is a big one. It can actually have a negative impact on your career and your reputation if it comes out that you didn't allow the client to make a choice. There's some Court of Appeal decisions about that where some people got caught on the wrong side of that decision. So always it's the client's choice. Now, it's not necessarily that you can't influence a client to go down a certain path. You would always get written instructions with respect to this aspect of a trial, regardless of whether the client chooses to testify or chooses not to testify. You have to protect yourself by getting a written instruction with respect to the final choice. Don't be afraid to weaponize your instructions. If you are trying to bring a client to a realization, in other words, if they're making a choice that is going to negatively impact them in a very big way, be extremely clear and explicit about that in your instructions. I have provided clients with written instructions that say something like, Ms. Freeman has reviewed with me my anticipated evidence. We have prepared for my testimony. It was Ms. Freeman's very strong recommendation that I not testify. She is concerned based on the content of what I am going to say and the way in which I am going to say it in front of the jury will have an extremely negative impact and will likely lead to my conviction. I have listened to her recommendations and I reject them. I instruct her to call me to testify. Don't be afraid to be that explicit. It will help the client realize very clearly what they are doing, and it will protect you when the client goes to the Court of Appeal, and you will have very clear instructions about what your recommendations were. You will have been very honest with the client, which is very, very important. And you can use that sometimes to get them to see the light about which decision they can make. With respect to preparation, I can tell you I have throughout my career tried a number of different timings of the preparation. And in my experience, the best timing that works for me is to start to prepare the clients to testify in situations where they're going to right hard up against the start of the trial and throughout the course of the trial. My clients' testimony has always been much more successful when I've done it that way. In my view, it has kept them from seeming overly prepared. They have testified in a more natural and genuine manner when I've done it in that way. The method that I use to prepare them to testify is just to ask them the questions that I would anticipate asking them, remind them of pitfalls, bring to their attention things that they're intending to say which aren't going to be helpful. You can never tell them what to say, but let me give you an example of what I mean. I had a first-degree murder case where the client shot the mother's boyfriend right in the execution spot behind the ear, and he'd done so after the deceased had been in a domestic dispute with the mother and slashed her face open by smashing a glass across her face. And during the course of the preparation for his evidence, the client kept saying, my life is ruined, my life is ruined. And I tapped on the table and I said, whose life is ruined exactly? Clearly not his. The person who was killed had their life ruined, and the mother had her life ruined because that man had been the love of her life. So you can assist them in that way, but you can never cross the line into telling them what to say. With respect to closing arguments, my advice is to keep it short and keep it interesting. Use props where appropriate. I always like to get a jury's attention with pictures or video or something to grab their interest. Standing up in front of a jury and reading at them for hours will not keep their attention, and you'll lose the flavor of what it is you're going to say. Myself personally, I've never found PowerPoints to be helpful or to be attention grabbers for a jury. I've never used them, but I've watched juries. The Crown seem to favor having PowerPoints, so I have been watching the jury's response to those PowerPoints when the Crowns are presenting them, and they're never appeared to be very engaged or interested in the content. Try to speak to them in an interesting way and not at them. Keep it as short as you can, because the longer you go on, the more you're going to lose their attention. Try to keep it interesting throughout, not just at the beginning and the end, so that you can maintain their engagement. Don't be afraid to go off the beaten path by using props or by using photographs. I can give an example of a jury address that I gave in a different murder where the issue was, it was a murder on Spadina outside a restaurant, in one of those after the club restaurants where people go. And there was a shooting right outside the window of the restaurant, and people were drunk, people were distracted. The shooting was very short in duration, a number of seconds. So I opened my jury address by showing a very colorful image. It was of a protest and there was someone in the front with a very colorful flag, and there were interesting things happening behind the person holding the colorful flag. And I turned the screen on for as the same number of seconds for which the witnesses had said they had viewed the shooting, and then I pulled the plug out of my computer so the image disappeared. And that's how I got their attention and drove home the point that you see something quick, and made the point that, you know, you were looking at the picture when you were sober, when you were expecting to see something, when you were paying attention, and these other witnesses had seen it like this when they were drunk and distracted. So if you weren't able to see, and then I pointed out the images behind the guy with the colorful flag, did you not notice this person? Did you not notice that person making the face? Did you not notice this person with the big gun? Imagine that what the witnesses weren't able to see. Because the theory of the defense was the real shooter was standing in front of the guy they had seen with his arm out. And they didn't see a gun in his hand. They could only see up to about the middle of his forearm. So don't be afraid to do things like that. Don't be afraid to break the mold. Take some chances and keep it interesting. Those are the topics that I wanted to cover. I was worried with questions about getting into too deep of a dive on this, because I wanted to get through some points that I thought were the most helpful. Jen, what do you think we should do? We've got quite a bit of time left.
Well, why don't I ask you some questions, and we can sort of explore some of these areas, and then we can open up for questions generally. Yeah. So one of the things I think that's really important about a criminal trial is to know and to read your audience. And your audience varies, of course. If you're doing a provincial court trial, a judge alone trial, you know, your audience is the judge. You're doing a jury trial, then it's a very different audience. It's the 12 members of the jury, and it can be a very different experience. And one of the things that some people say about jury trials is that there's a bit of a theatrical component to it, a bit of acting and doing certain things in front of the jury to convey a message without coming right out and saying something. And Sid, I don't know if you have any comments on how, or if you consider that kind of thing and when you're doing things in front of a jury, doing a trial in front of a jury.
100%. I think that's a great point. Judges on judge alone trials are not going to be impressed by theatrics. In fact, they're going to be put off by theatrics. So it's important to save that for the jury. Now, that having been said, there are some instances, even in judge alone trials, where you shouldn't be afraid to telegraph your disgust at a witness who's clearly lying, or a police officer who's not telling the truth. But you would perhaps not go as far as you would in front of a jury to indicate your distrust of that particular evidence. Don't forget, you know what, I do some, the U of T has a summer program where they run students through a mock trial, and I do some teaching there. And what I tell the kids is, and I think it's appropriate for us as well, really in a criminal trial, we're telling a story. We are storytellers. And it's like making a movie where the witnesses are our actors, right, and actresses. Use the forum you're given to tell a story right from the jump, because a story is engaging, a story is entertaining, a story is something that the trier of fact can wrap their mind around and sort of understand and get invested in. So to the extent that it's appropriate and you can do it, be a storyteller, be a movie maker, and tell a story with the evidence. And then in your closing submission, you that's where you tell the story. That's the narration, right? The final summary of and conclusion of your movie, where everything comes together.
I think it's important because you know, when you're in front of a jury, sometimes you want to actually send a message to the jury, but you can't, obviously you can't give evidence, and you want to be careful of the questions that you're asking particular witnesses, because you never want to ask a question you don't know the answer to. But there's also sometimes in front of a jury where you want to ask a question, you know the answer you're going to get, but what you want the jury to hear is the question. So for example, I had a case where my client was interviewed for 8 hours by the police, and the officer over and over again put his theory of the crime to the client. The client just denied and said whatever. He said things like, the officer said things like, your alibi is weak. This is not very believable, et cetera, et cetera. And I put to the officer, knowing, of course, he was just going to disagree with me, that he was speaking to a future jury, that the officer was conveying a message, knowing this statement might well go in front of the jury. And there was no point to my questions other than the jury hearing, this is a ploy on your part. This is a tactic on the part of the police. So sometimes you can keep in mind the audience and what you're doing, and in terms of, you know, what kind of message you're trying to send without being able to come right out and say, oh, this was just a tactic on your part, et cetera, et cetera. It can be very effective, and it's also kind of fun, particularly with police officers.
It's a really good point, because, you know, we'll always hear the judge say to the jury, the answers aren't the evidence. But that's denying basic human psychology, right? I mean, the jury is here, or sorry, the questions aren't the evidence. The jury is hearing the questions. And you can use your questions to plant seeds in the mind of the jury, right? Plant a seed about your theory, plant a seed about what the officer is doing. You can use your questions effectively, even when you know the answers are not going to get you any further down the field. Sometimes the questions are the point. Sometimes the answers are meaningless and irrelevant. You know,
so another thing I think, sorry, go ahead, Sid.
I'll give you an example. Say you're doing a sex assault case, and you know that the complainant is going to deny your theory, right? But in order to get your theory to the jury as quickly as possible, you're going to ask those questions anyway, right? You're doing this out of malice. You know, these are stupid examples. It just came to the top of my head, but you had tried ending the relationship and it didn't work. You tried moving residences and it didn't work. You changed your phone number, it didn't work. You tried everything that you could, and finally you resorted to making up this allegation, right? That's something that happened in a case that I did earlier in my career. This poor woman, and I felt bad for her, but she'd done everything that she could to end the relationship and make him leave her alone, and he was persistent. And ultimately she made this sort of complaint, knowing that there would be conditions that he not be allowed to contact her, and it was the questions to her that were the relevant part of the cross-examination, not her answers, because I knew she would deny that that's what had happened. And that technique can be used in every scenario. So despite what the judge is going to say, that the questions aren't evidence, the questions are actually pretty important sometimes.
Definitely. And I mean, I think the whole idea about reading your audience, that is a very big point in terms of everything that Sid has just said, in terms of actually whether you're doing a trial in front of a judge or a jury, but also goes to the issues about cross-examination. If you're in front of a jury, you're going to potentially have to change your tactic with respect to how you're cross-examining certain witnesses, because you don't want to turn the jury against you. You don't want to lose credibility with the jury. You know, it may be a case where, you know, you can't go that hard against the victim because, or the complainant, or the reputation of the deceased or something like that, because there's already some sympathy there from that the jury clearly can see. So again, it's reading your audience with respect to your cross-examinations as well. Obviously, if you're cross-examining a child witness, your audience is going to be sympathetic no matter who they are, presumably. But you have to keep that in mind as well. A judge alone trial is not going to be as concerned with respect to, you know, how you're handling certain witnesses. You have to be very, very careful with that in front of a jury in terms of keeping your credibility with the jury, because they can turn on you in a dime.
Yeah, you have to keep an eye partly on the jury to gauge where they are and whether they're still with you or not. In addition to knowing your audience in terms of who the trier of fact is, you also have to know your witness, right? And you have to be able to read them as you're going. And, you know, in terms of sometimes the questions are the point. There are examples, for example, in assault type cases. So if you have an assault, say an aggravated assault complainant, and your theory is that it was actually the complainant who was the aggressor, sometimes use your cross-examination just to make them angry. And if you can succeed in making them angry in the courtroom and physically violent even in the courtroom, and bring out that temper in the courtroom, then you're showing the trier of fact what this person is really like. Like, they can't even control themselves in this setting. Imagine what they were like outside of court with a few drinks in them. So I did an aggravated assault case one time, just exactly like that. And my whole goal of my cross-examination wasn't to induce any particular bit of evidence from the mouth of the complainant about the case and about what happened, because I had no expectation he would tell the truth. Instead, my whole goal was to make him really, really angry and to show the court who he was as a person, to give greater credibility to the defense theory that he had been the aggressor. And in fact, I had needled him so badly that partway through the cross-examination, the police officer very deliberately put down his pen and pushed back his chair, because he was getting ready to intercept the guy, because he was very close to coming off the stand. And you can be very successful in your cross-examination using techniques like that. It's not always about the words that come out of the witness's mouth.
So I see it's 1:45. Why don't we open it up to questions, and I can fill in with some other questions if need be. I can see that there's already a question in the chat, and that's for you, obviously, Sid. Do you have tips in terms of retaining, memorizing the information in your closing or opening submissions?
So I am one of those people that writes out everything. I write out my cross-examinations. I write out my closings. I do that largely for two reasons. One, it dramatically lowers my anxiety level. And the other thing is that it helps to prevent me from forgetting things that I wanted to say and areas that I wanted to cross on. I also find sometimes when I'm writing out my cross-examination, I'll come up with new ideas just from the flow of the preparation. So that's my my main technique in terms of those things. I do, though, try to memorize to an extent that there's time for. There's not always time for this in a trial, but especially a jury trial. But to the extent possible, I do try to memorize portions of the closing. It's important to not just stand up there and read. You're going to lose engagement with your audience. Try to connect with them, look them in the eye. Pick people that you think a particular point's going to resonate with and say that point to them. Keep engaged with the jury to the full extent possible.
I just did a closing address the other day, and I've learned it's the same thing. You don't want to be reading your closing address to a jury. You want to, as Sid says, be engaged, look them in the eye and so on. So one of the things I've done, and it's partly because I'm getting older and my eyes are getting bad, because I also write out my closing, is I print it in very big font. It's in a binder, of course, and then I highlight keywords on each page so that when I glance down, I get the reminder, okay, this is where I am and everything. And I mean, like Sid says, you're going to memorize certain sections, and certain sections are just going to come to you and come out because it's the evidence. It's the points you've been thinking about, dreaming about, whatever's been going on for however long the trial is. So those things are going to come out of you quite naturally. You're going to have those pieces where you're tying it together, or you want to have those punch lines, so to speak, that you'll want to remember, and you want them to come out perfectly. And those are the kind of things you're going to highlight in there to make sure it comes out. That's a very simple little thing, but I find it works for me.
Yeah, that's a great practical tip. I always print my closings in huge font. And I like
mine are getting bigger.
Yeah. Are there other questions?
So, I don't know how to unmute people, or if they just do it themselves.
They will need to do it themselves. Yes.
Hello.
Hello.
Hi, it's Nancy Cooper speaking. I've been practicing criminal law for about 15 years. Before that, I did some family law. And I'm generally a courtroom lawyer. In my trials, and I'm 1-2 for writing out my scripts for my cross exams and my exams in chief and the whole bit. But I always end up getting thrown off. The witness, it never goes according to script, does it ever? So I want to know primarily, do you have any tried and true techniques other than the closed question for witness controlling a witness. When a witness doesn't answer the way you expect them to, and tries to take over the examination, and the judge say is not one that likes to intervene.
So that's a really good question. Thank you for asking that. I have done things like when a witness tries to take over and just talks and talks and talks, I'll actually turn my back on them and start walking away towards the bar. And then I'll lean against the jury box, and I'll look across the room, and I'll just wait until they stop talking, and then I won't say anything for a period of time. And then I'll look and I'll say, "Are you done?" You know, that's one technique you may want to use. If they're a runaway witness where they won't give you the answer that they've given before, you just have to stick with them. Sometimes it's like, you know, riding a bronco at a rodeo. You just have to keep on them. Sometimes police officers won't give you the answer you want when you're trying to quantify things. Like, I can't remember a specific example, but I know when I think that the officer's never done something before, and he says or she says that they have, I'll say how many times, and they'll say, I don't remember. And I'll say something like, is the answer bigger than 0? You know, you have to be, part of this job is being creative and being able to ride waves, quite frankly, and keep at it. Again, like the eagle keeps going down for the fish, or the bear keeps, you know, trying to go for the honey. You just have to keep at it and keep your courage up and not let up until either you get what you want or you make the witness look like an idiot for not giving it to you.
Yeah, I agree with that. I mean, this isn't a helpful point, but I think every time you cross-examine someone, you get that much more experience and that much more confidence in terms of dealing with those super annoying witnesses who are out of control or just won't answer the question. And I agree with Sid, it's a bit of a tactical decision. If you get that point that you want and you now have launched into something maybe that's not really, really necessary, and you find that you're now in this argument or you've lost control of them, you might just pull it. You might just say, okay, I've got what I wanted. I'm sitting down, go get in, get out, because there's someone who's just going to argue with you and it's really not going to help. But again, it's a tactical thing and it's a judgment thing that you get with experience in terms of whether it is better for you to have this witness just look like someone who won't even agree that the sky is blue. Then they just look stupid. But it just comes with some of it. I mean, uncontrollable witnesses happen to everybody, no matter how many years of experience. You'll just feel a little bit better handling it each time you're doing another cross-examination.
Yeah, I 100% agree with that. And, you know, even though I write out my cross-examinations, it's like what I said before about having a bit of a chameleon about you in terms of how you approach witnesses, even after you figure out who you're comfortable being. Sometimes you just have to throw it away and go with the flow. Right? Or sometimes you have to depart from it for a moment and go with the flow. One of the most important parts of cross-examination is listening. You have to listen to the answer.
100%.
Because
that's where you got to watch your script.
That's right.
You have to listen. Yeah.
You have to listen to the answer, and you have to not just hear the words, you have to hear the nuance in the words, because sometimes the witness will say something and you go, the light bulb will come off. Right? Because they've said something or they've said it in a way that gives you a new path to go down. Listening is really important. It's a really important part of a trial.
Those are all really good points. Thank you.
Do we have questions in the chat?
I have a question to both Sid and Jennifer. Following up on what you just said, do you use any any sort of like, you know, pacing in terms of like, you know, how you ask a question during cross-examining as a way of like jarring the witness or making them feel a different way? Is there like a pacing tip that you may have when you're asking questions while you cross-examine?
I don't know about you, Jen. I don't know if I use pacing of questions as much as I use tone. I use a lot of tone in my cross-examinations. If I don't believe you, it's quite apparent. If I'm sympathetic to you, it will be apparent. If I'm neutral, it'll be apparent. Tone is a very powerful tool to use in your cross-examination. I don't think I've ever used pacing as a cross-examination tool. What about you, Jen?
I mean, I have used it. There's some, you know, if you're going to do a cross-examination at trial after you've had a preliminary hearing and you know you're going to get those answers, and then you've got that one last one that you didn't ask at the prelim, then you might go through and do those relatively, you know, quickly to catch them, because there's that one answer you didn't ask at the prelim that you now want to get at trial. So that might be something that I would do for sure. That's a pacing thing. The obverse of that is I prepare my clients who are testifying for pacing questions from the Crown by having them tap after every question by the Crown, just to make them pause, just to make them think, give them time to stop the pacing by the Crown. And every single client has really benefited from that, and really taken that piece of advice in terms of just slowing it down so they stay calm, they don't get drawn into what the Crown is doing.
Thank you so much. That was the last point was really helpful, especially for clients that oftentimes are not very good at testifying.
And are super nervous. Yeah, definitely.
Yeah, I mean, one tip that I give the clients who are testifying is this, and it, you know, it may be culture specific to my culture. I'm from the East Coast, and we have a kitchen table culture there where all of our big conversations are done around the kitchen table. And what I say to the clients is, you know, I check with them about their culture first, but if it's something that resonates with them, I tell them to treat a cross-examination and all of their evidence as a kitchen table conversation. Something's happened in the neighborhood. You've got to go over to the neighbor's house and sort it out with the neighbor. The neighbor and the family are all there. You're all sitting around the kitchen table. The tea is out, the cookies are on the table, and you're just explaining your side of what happened in the neighborhood dispute. And that I have found to be very successful in eliminating a lot of the intimidation. And I tell the clients, this is your chance to tell your side of what happened. And when the Crown is asking you questions, this is still your chance to tell your side of what happened. Use the Crown's questions to explain your side about what happened. And remember, the jury, they're just the neighbors sitting around the kitchen table, and you're all just having a conversation. And that's all it is. That's been quite successful as a technique for the clients, in my experience.
Looks like we have time for maybe one or two more questions.
Maybe to follow up on that again, I know Sid, you mentioned earlier that, you know, you use tone. Is sarcasm, does that ever come into play? And how do you sort of like, you know, keep a measure on that, not to offend, for example, like, you know, the judge or the jury that are around?
I have used sarcasm. That's a very tricky one. You really have to be very alert to where the line is when you go there. And you have to be very astute in knowing whether it's okay to go there. I have been sarcastic mostly with witnesses who are just not believable, including police officers, but I use a sarcastic tone probably more than a sarcastic set of words in my cross-examinations. Like, I wouldn't say something like, well, that's what you say, or something sarcastic like that. But I guess probably an example of something that I've said that's sarcastic is when I ask the police officers, is the number of times you've done that greater than 0? That's probably as much as I get overtly sarcastic in words. I use much more sarcasm in tone. What about you, Jen?
Yeah, I agree with you. It's a very tricky area because you may get slapped down immediately by the judge because it's not appropriate, depending on the question. Other judges may just do a hands off, and you're going to leave it to they're going to leave it to the Crown to object. It's a play it by ear. You could try it, see if you get away with it, but you got to think about what are you trying to accomplish with it? Are you just trying to make the witness look like an idiot? then maybe you can do it without sarcasm, but it just, what's your goal with being sarcastic, I think is what you need to think about. And is it worth the potential consequence?
It's really easy to lose your audience with sarcasm, I think, especially with the jury.
Yep.
I just received, I know we have a few more minutes, but I did receive just one last question.
Sure.
And the question is, any tips and tricks for the preparation of the cross-examination beyond, I'm assuming, what you've already discussed?
Stay tuned for our next CPD.
Okay.
Yeah.
Thank you.
Lots and lots to talk about in terms of cross-examination. There's, thinking about what you want to get out of the cross-examination for each witness, then how you prepare that cross-examination depending on statements, prelim transcripts, then style of cross-examination. It goes
yeah. The order of
on
your
and
questions
on.
is actually really quite important because, again, you're storytelling, right? So you've got to, I always sequence my cross-examinations. I have a different section for every point I want to make. And I actually put them in a specific intentional order to best tell the story. There's lots, Jen's right, there's lots and lots and lots to discuss for cross-examination. It's a difficult topic to
so
do justice to, as part of this CPD. I hope Jen and I have given some tips that will be useful, but we'd love to do another one focused just on the cross-examination area because there's so much to cover.
Thank you so much, both. This was very interesting. I think that's the time we have, and definitely stay tuned for another WiCCD CPD to come about probably cross-examination and more. Thank you so much.
I'd like to thank everybody for coming. It's been a pleasure speaking with you today.
Thank you.
Bye, everyone.